Also present from the building department is zoning inspector Chris Hall and law director Mark Gaddetti and secretary Rachel. All persons in the audience are required to sign in on the registration sheet. If you have not done that so already, please do so now. Has everybody signed in, whoever wants to talk? Okay. If you wish to speak at this hearing, you will be required to be sworn in as any court hearing. Does any of the board members have comments for the minutes from last meeting? None?
No.
I make a motion, we accept the minutes from the last board meeting.
I'll second that.
Thank you. All persons wishing to speak on an issue will please raise their right hand and affirm this oath. Do you solemnly swear that the testimony you will be given before this board is to the best of your knowledge and accurate and truthful presentation of the facts? If so, say I do.
I do.
Now in turn, please state your name and relationship to the case for the tape recorder of voice recognition. You could do that when you come up, okay, per case, all right? The hearing will be conducted in accordance with the provision of the Ohio Sunshine Law. The notice of the hearing was duly published in a newspaper in general circulation in the city of Macedonia. The notice is available for review upon request at the building department. The rules of the board require affirmative vote of 3 members in order to pass, regardless of number of members present at the hearing. The hearing is conducted in an informal manner to review the evidence and so respond to questions. However, there is an outline of steps that will be taken in order. An appellant does not have to be present for the board to hear the case as publicized. Each case number and appeal request will be announced as the turns arrive. Okay. Case number 705. All right. The first case is number 705, and the appeal form is in order. Secretary, is there any correspondence from notified adjacent property owners?
No,
Is there any unsolicited correspondence regarding this case?
no,
Is there any correspondence regarding this case in the audience?
I would like to speak.
Okay. You want to do the zoning inspector first, the city's response on this, or should we hear from the audience first?
You can hear the city's position at the outset, that's fine.
All right. Will the zoning inspector now please state the city's position?
The Board of Zoning and Building Code Appeals will hear a request for an area variance for Don Bash Jewelers at 8226 Fairlane Drive. The variance request is to section 1179.03 F2. The maximum permitted area for identification signs is 2 square feet for each lineal foot of building frontage, and 1179.07 F2 regarding large building setbacks. The applicant is requesting a variance of 31 square feet for an additional sign on the north tower wall.
Does the board have any questions to the city? No. We'll allow Mr. Repeck, would you please come up and speak? You can sit up. Well, you can stand there. We have the mic on. Go ahead.
Okay.
Thank you.
Thank you. My name is Terry Repack. Excuse me. I live at 8250 Harmon Drive, which is immediately to the north of and across the street from the existing Bash Jeweler building. I am speaking against a variance for this sign for several reasons, and I'd like to address the letter that was written by Mr. Dustin Bash regarding the reasons for the sign, for the variance. The first item I would like to talk about is the phrase, "We think it would be more presentable with all sides matching in size and shape." That's an objective statement. It has nothing to do with fact. It's a personal opinion, and it's easy to disagree with. Number two, the applicant says they're requesting this sum due to the hardship of visibility because of the unique shape of the lot. When this lot was purchased several years ago and the building located, at that time, everybody knew it was a unique shape. Everyone knew it had unique problems. And the Board of Zoning Appeals, you folks, gave the applicant, I believe, 5 variances, including roughly a 70 to 75-foot setback variance, which brought the building as close to Route 8 and my property across the street from Harmon Drive as possible. At that time, the application was made. There was a lot of comment about the screening between my property and the proposed building, which was a fairly dense wooded area, if you will. Not very deep, but dense enough where you couldn't see anything. Within the last couple of months, all of that vegetation has been removed. Mulch put down, and the vegetation has been removed roughly 12 feet high from the ground. So there's no screening whatsoever between the building and my property. The third item that I would like to talk about is the building code needed to develop the property with the least amount of impact. Well, the least amount of impact is long gone by. There is no more least amount of impact because the property and the building is right on my property. The next item, the next sentence says, the practical difficulty was brought to our attention from the public as, quote, we are hard to find. Again, not a reason for a variance. The owner of this property purchased that property knowing that the property was behind a building. It was isolated from all the rest of the, visually isolated from all the rest of the commercial properties in the area. And the location of the building was selected and a variance granted so that the owner of the property would have the maximum amount of visibility from Route 8 so that he could, and at the time it was mentioned, he could increase his business because of the visibility. A second time it mentions no substantial impact on the adjoining property due to the height, foliage, and general facing direction. Well, we already know that the foliage is gone. There is no blocking foliage. And there's nothing to say that the rest of the trees, the rest of the foliage on that property can't be removed at any time, exposing the entire building to the residential area to the north. And the last statement, I think, is very revealing as to motive. It says the sign would face north, quote, to capture those heading south on Route 8 at 50 miles an hour. That is not what you want traffic to do at 50 miles an hour, is to look off to the side and see a sign when you have a traffic light and a very congested intersection within 200 or 300 feet of where you are, taking your attention away from what you're supposed to be looking at is the traffic in front of you. I don't know if I should mention this or not because I thought of it on the way here, but first of all, I would like you to decline the variance for the 31 feet for any sign, but you can't decline a sign that meets the variance. I know that. Right now, there are signs on 3 of the 4 elevations of the main elevations of the building. Yet, in my opinion, and the code is a little bit difficult to understand here, the building has 2 frontages, one on Fairlane and one on Route 8. I'm not sure that the frontage or the side of the building facing Harmon and South Farm can be considered a frontage. I don't know because it changes zoning, but if you read the code, it says commercial buildings shall have only one frontage. And then it goes on to say that you can put a sign on the second frontage, which to me is a little bit confusing, and I don't really know how to read that part of the code. But anyhow, what I was going to say was, if you deny this variance, I can imagine with this tower that the signs are proposed to be placed on, which has windows on 4 sides, that when it gets dark, that some kind of a bright flashing light from inside the building is going to be installed so that it draws attention to the building, which there isn't anything you can do about, because all he has to do is flash, after they close, have a flashing light on there to create an attraction. So, I mean, there are ways he can call attention to his building, but that would be obviously extreme. But anyhow, the point is, I'm against the variance, and especially any sign, but within the zoning code, there's nothing I can do about that. So that's all I have to say, and I thank you for your attention and your consideration.
Thank you. Now, I guess we'll have Mr. Bash, if you'd like to come up, whoever would like to come. If all 3 want to, bring another chair, please, if 2 of you. Go. Did you sign in?
No.
Please sign in. Should I swear him in too? Since you weren't sworn in, I'm gonna have to swear you in. Okay. All persons wishing to speak on this issue will raise their right hand and affirm this oath. Do you solemnly swear that the testimony you will give before this board is to the best of your knowledge and accurate and truthful presentation of the facts? If so, say I do.
I do.
Now, in turn, please state your name and relationship to the case for the tape recorder. Both these, please.
Don Bash Jr., owner.
Dustin Bash, manager.
Okay. Well, gentlemen, go ahead. We're listening.
So obviously, taking into consideration adjacent property owners, their comments, we did, as he said, we did clean up the foliage underneath. However, the high-rise trees and all of that did stay. Reasoning for the foliage getting removed is there was actually a homeless person in there living, and we didn't feel like it was
And there's security interest still
exactly
there.
yeah. So it's cleaned up. I think it looks very nice. You guys can give your opinion, but as far as the sign being visible, we did leave I don't know, it's got to be a 50-foot pine tree, which I submitted with the application. That is actually where the sign would be, and actually shot out towards, that would be the north. So that's the actual height and placement of the sign. I took a drone video and actually put the drone where the sign was and shot it out and captured a picture. So that evergreen there. This one, it's got a dual photo.
Okay.
Yeah, so that's actual height and placement.
The sign will be on this side.
It'll be
It would be
facing the way
behind
the
you,
drone
right.
picture shown.
Yes, you are the sign looking out,
Drone
correct?
is the sign.
Yeah. Yeah. So, with that being said, the sign it'd be approximately, going off the other ones, about 28.7 feet in the air. So, that would be the bottom of the sign, and then only continuing higher from there. Next, you got the photoshopped image, so that would be basically where the sign would be. I just took a snapshot and moved it over just to give you an idea of what it would look like. Lastly, just some shots from, that would be what, South Farm, right? South Farm? Yeah, South Farm Road. kind of showing how the tower is visible. And I guess to Mr. Repak's point, we can't capture people when they're going through the intersection, right? People can't see that, and that's, you know, basically how we came across this, is you've already hit the intersection, you already have to make a decision where to turn at 50 miles an hour, and we don't want that. So basically, this is giving people advance notice of where we are to then be able to get in the correct lane.
And real quick is, I see this Photoshop one, this is where you're talking would be, when you talk about advance notice, you do have a sign on the west side and on the south side.
You're sitting at the intersection
Yes.
already to see the west facing sign.
Are you, is the north, the west side at the intersection? It's not before the intersection, is it?
It's like right in between, I would say the middle turn, the middle of the turn lane.
But we do have a sign on the west and the south side.
Correct, yeah, so this is traffic coming south on routing.
So where's the third? I heard there were three signs already? There's two on the,
So on the tower, unless he's referring to the monument sign of the driveway.
oh, like on the other side.
Yeah.
And then one on the side of the building too.
There's one
on
on
the
the
side.
face of the door,
Yeah.
but that's back in, nobody's seen that until you're in the
That's on
parking
the
lot.
But it's signage.
I have a question.
Sure.
I received an email today that came from our office, that you sent to our office, saying that you were already approved for this sign.
We are approved for basically the letters.
27.15 square foot.
I
It's
brought
been
it up.
approved.
Planning commission has approved,
Yes.
not
Okay.
BZA.
Yeah.
Right.
They've
But,
approved it.
but they're looking for a variance for the 58 plus 30 square foot.
In layman's terms, all we're asking for is extra square footage, so all three signs match.
Yeah,
Yes.
that's what I was gonna just
That's
ask.
where the
That-
var-
so the variance is just for the square footage, not about the actual
Minimum.
sign.
Yeah.
Right. Because it's been approved already by planning commission, but the only thing that's been approved is the 27.15 square foot.
Well,
The variance is for the 58.30 square foot, which they want. And here's the difference.
Yeah.
We didn't get a picture of it or printout. There's the difference.
It's a logo or something, I thought I read it.
Right.
It's the way they measure the distance in squares.
So I guess if that's the case, and you got approved already for the 28.7, does the logo really mean a lot, or, I mean,
Consistency. I mean,
so if
I
you,
mean, it's not gonna be that much difference in,
would you rather see the logo or Don Bass Jewelers? I mean, if they're coming,
Yeah, I mean, obviously, Don Bass Jewelers, the way we submitted it.
Well, I made 4 trips, east, north and south on Route 8.
Sure.
And I just visualized, I see the sign facing west. When I'm coming south, that sign jumps right in. The other sign, to me, is covered partially by the wooded area.
we want the people coming south to be able to see that sign as you saw
But it's
coming
still-
north, to be able to be in the right lane to make the turn to get around the corner.
Correct, yeah.
But it's so close that they're gonna go from the right lane to the center lane. We're looking for trouble.
The way it presently is, yes.
Yeah.
This is gonna alleviate somebody trying to
Like a
get
north
across
Thank you.
to make the left-hand turn. So that's what we're looking at. And we waited to see comments, and that's why we've been open over a year. Because this is some feedback for it.
Thank
so
you.
theoretically, after seeing that, because I have a,
No, this was drawn after the
Right.
comments by the Brian Franz. I'm sorry, I can't remember his exact title, but
city
planner.
So theoretically, per the code, you could put this without the diamond.
that's
Correct.
correct. Because it's been approved already by planning commission.
And, okay, so either way, there's a sign code.
Correct.
So like, it almost renders all the other points moot, right?
Yep.
The sign's going there anyway.
Correct.
It's just, is the diamond gonna be there for consistency or not? That's pretty much it.
And if code's the 28.7, that's approved, then it's 28.7, that's the code. So the variance is with the logo.
Right.
And is there a hardship or
Well,
anything?
the hardship's people just not having somebody shifting lanes coming south, that jump in the wrong lane or pass it by.
Is the hardship gonna be the same with the logo or without the logo? You think? I guess is what I'm asking you.
I wouldn't think.
Let's be honest, there's not gonna be a hardship,
No.
but when they walk into the store, it's not gonna be, we decided to do that. We just unfortunately have to say, that's what, I mean, I hate to say it like this, but it's kind of the decision that it was made not to make it look right, because the diamond isn't even what puts off light. As you can see, it's all black. The more lit up part is the Don Bash Jewelers. So it really is just a matter of making it look uniform, which in design, I would think that, just my opinion, once again, but the city would want them to match. Otherwise, people are gonna be, well, why is this? And because you're getting 31 feet for a diamond, that's no bigger than the placard that's hanging on the back wall.
No, but we're here to look at the square footage, total square footage of all the businesses, not just one business,
Correct.
okay? And, you know, once we've received this memo, okay, that the 28.7 square foot is approved already, all you have to do is go to the planning commission again, all right? Versus the variance of the 58.30, I mean, in one way, it's, you know, do you have to come and get a variance, or don't you? You're gonna get the sign anyhow, as you said. Any other comments? Ken?
No.
Anything?
Sorry, I'm just thinking.
Go ahead, I'm waiting to see if you have any comments, that's all. And, you know, like I said, as you were pointing out, that there's really no hardship, okay? The sign's gonna be there whether the logo's there or not, okay? That's, we have to look at,
Mhm.
okay? Chair's open for any motion, gentlemen.
I make a motion, I'll make this correct, that we deny the variance of
58.30.
58.30. And go with 28.15.
Anybody second it?
I just want to be clear, so you guys know that the 27.15 is what we already have in a bank, right? So we have a certain amount, 27.15 is already our pre-allowed.
That's correct.
Okay, so our our variance is only 31 square feet. I just wanted to make sure we were clear on that.
That's, we got, thank you.
Yep.
I'll second the motion to deny the 58.30 and accept the 27.15, which has already been approved by planning commission, and all you have to do is revise it. Rachel, will you do a roll call?
Mr. Pilato?
Yes.
Mr. Ferraro?
No.
Mr. Shalfo?
Yes.
Mr. Iafreda?
No. Wait a minute.
So your motion was
Yes.
poison and negative, it fails, so you're really,
Yes.
I would suggest making the motion in the affirmative. Motion to pass the variance and then have a vote on that. Might be a cleaner way to do it.
To pass the motion?
But somebody in the side that would vote yes? would
So
have to-
typically you'd have a motion in the affirmative, so a motion to approve the variance.
Can somebody that does the motion still, in the affirmative, still vote no on it?
Say that again?
Somebody makes a motion to approve the case, and they then say no in the roll call?
Yes.
So I'll make the motion that we approve the request as submitted.
Anybody want to second that request, that motion?
Second.
Roll call, please.
Mr. Pilato?
No.
Mr. Ferraro? Mr. Shalfo?
No.
Mr. Iafreda?
No.
Okay. Case 705 was denied as presented.
May I say one more thing?
1 second, please.
Okay.
Okay. So basically with the time, we're gonna just go back to the planning commission and get everything figured out with them, and you'll be able to go.
We're squared away.
I would like to publicly thank the Bashers for solving the light leak problem that occurred after the trees came down and whatever onto my property. I no longer have light coming onto my
There's
property.
3 of them there, Terry, so.
So,
We're always gonna need that.
Thank you, Mark.
thank you.
Thank you. Seven oh six. And who are you for?
I'm for the Valley Reserve project.
Okay, I have to swear you in, come on up. Since you weren't here also. Then, all persons wishing to speak on this issue will please raise their right hand and affirm this oath. Do you solemnly swear that the testimony you will be given before this board is given to the best of your knowledge and accurate, truthful presentation of the facts? If so, say I do.
I do.
Please state your name and relationship to the case for the tape recorder voice recognition.
I'm Dan Barsakowski. I'm with MG Civil Design, and I'm the civil engineer for the project.
Okay. We're going to announce case 706, and the appeal is in order. Is there any correspondence from any notifying adjacent property owners?
No.
Is there any unsolicited correspondence regarding this case?
No.
Will the zoning inspector please state the city's position?
The Board of Zoning and Building Code Appeals will hear a request for an area variance for Valley Reserve Development. The variance request is to section 1163.02A5 regarding planned unit developments. The applicant is requesting a variance to have 59 lots instead of the allowed 58.
Is there any questions to the city from our board? No? Okay. Presentation?
Sure.
You're more than
Yeah.
welcome.
The first question I have is, did you get the letter from Mr. Koblenz?
Yes.
Okay, all right, I just wanted to make sure. I know he told me he sent you a letter.
I can't, this one here?
Yeah.
We have.
Okay,
Thank you.
great. So I'm here on behalf of Chris Koblenz, the developer. And as it was stated, our subdivision, we went to planning commission, we came up with this layout. It's a residential subdivision, and we proposed 59 lots. We had the lot surveyed, and we knew we were gonna be on the brink of whether we would be at 59 or 58 with allowable lots. The final survey numbers have just came in, because we have a consolidation plat for this land now. But the reason we're here for the variance is to get this 59th lot instead of 58, which is what the code allows. There's a couple of points I'd like to make on our behalf that I think it makes it a reasonable argument to allow the 59th lot. One is, in doing the calculations, we take the surveyed area of the lot, we subtract out the right-of-way, and we multiply by two dwelling units per acre allowed, and that gives us allowable density for the parcel. And our surveyed acreage was 29.1973 acres, which would allow us 58.4 units. So we were 0.1 of an acre away from being allowed to do the 59th lot, which would be just the rounding, 58.5 would allow us to get 59. So about 1/10 of an acre, or about 4,000 square feet of area.
What did you say you came up with originally? The density?
Allowable would be 58.4 units.
Right, but I'm talking about, total acreage. You
Total
have-
acres was 29.1973, which is a little less than we submitted. So we're actually a little further away, but it's still a tenth of an acre short of being able to round up to the 59.
Okay,
Another point is, we did a density exhibit, and it's based on, the code allows no more than 6 acres per acre in any box in the subdivision. So we put this exhibit together, and there was only one box, which was box K, that we had the 6 units, and the other ones were pretty far from that, so it's not a super dense subdivision.
Where does that number come from, the 6 per?
There's 2 density checks. One is you're only allowed the 2 dwelling units per acre, but then there was also like an underlying code item that said, basically, in an acre box or square, the maximum amount of units you could have in that box is 6.
Typically, what the city planner will do, will take a square, I'm gonna assume that's the appropriate size, and move it around to determine in any given acre, does it exceed the statutory maximum number of units? Sometimes it's referred to as a specific density versus a general or overall density for the PUD.
Got it. Thank you.
so he does it for the whole development.
Correct.
Yep.
Go ahead.
And then the third and the last point we have is this subdivision has acreage in Hudson. And it shows up on, if you have a title sheet, you can see that this lot comes to at the southwest corner. This was presented as to show all the land in Macedonia. These 2 lines, if you could imagine, they actually converge to a point. So part of this, what the developer owns, there's 1.35 acres in Hudson that we weren't allowed to use for our density calculation, but it's going to be included in the open space of this subdivision. So we couldn't use it for the density, but it's going to be in perpetual open space, not to be developed. Which we think, that almost rounds up to 2 units. We're just asking for the 1.
But that's in Hudson, that's not in Macedonia.
That's true, it's in Hudson, I think it's important to make the point that, and we realize that it's in Hudson, it shouldn't be used for the density, however, it's still, it's no different, the open space that's gonna be in this triangle is no different than any of this other open space, which we're proposing a lot of it. If it were hypothetically in Macedonia.
You would be sitting here.
Right, exactly. So, and it's a landlocked parcel, it'll never be developed, and the developer is willing to plat that with this subdivision and just basically to put it in that perpetual open space, which will serve as a buffer to the residents. And that basically concludes our stance on this, and we would hope that you'd agree to give us the variance.
I'm reading over the memorandum from Brian France, and the website reflects 28.32 acres on the Summit County Auditor's website.
Mm-hmm.
Okay, which is less than what you're even proposing here, okay? So, I mean, it's,
And I do have to say that is not subject to a survey. That's the accurate information is when you have the land surveyed. So, and this sounds like it does get confusing. But Mr. Koblenz did have a subdivision here. If you guys recall that, it was called Valley Reserve, and it was bigger lots. But he had that land survey. So this project has 3 separate parcels. So this was surveyed with the part of the original project, And then when we put everything together, we use this real survey number with the GIS to get our number. So you're gonna have what's on the GIS, you're gonna have what we submitted here, which we submitted, 29.22.
Right.
We hired Rich Cole and Associates, who's a professional surveyor, to do a boundary survey. And he came up with a little bit less than our number. He's at 29.1973.
Okay, and going back to what I said, the county, Summit County auditors reflects 28.32.
Yeah, I understand. I think it's important to note that that's.
The county auditor's website, I mean, he's correct in saying a survey will be more accurate typically than the county auditor.
And the reason for that is because if this, that could have been a survey that was done 60 years ago. So as time goes on, normally, you know, with technology, things get a little bit more accurate. So when we will eventually submit a plat, and that plat will show the 29.1973, which times 2 is 58.3946.
Could you bring the other drawing up with the 6 units?
Mhm.
and-
Quick question, sorry, is there a reason why between 21 and 22, there's an open pie, and that those aren't just like together?
It's just, you know, we kind of plan that out for,
Drainage or something?
exactly, there's 3 things, drainage, and there's the possibility, when we move forward to final subdivision design, we have to submit to Cleveland Water, and they may ask us to loop the water lines. So we did this to,
Gotcha.
it kind of gives us, and also drainage, because this drops down. So instead of going towards the houses, we'll probably put a catch basin in here. So yeah, that's.
So you need all of that land, is what you're telling us, and the planning commission, that for water or whatever utilities that have to go through?
Yes. Yeah.
And then what would you do if the variance wasn't granted? Like, is-
Good question. We would basically keep the road infrastructure the same. We would just,
That would be the only section that would have just about what everything else has, instead of 6.
yeah, we would probably just figure out a lot to get rid of and maybe absorb the acreage over 3 or 4 lots.
Do you know what the smallest lot is on this, out of all 59?
Yeah. It's, do you have a calculator?
Yes.
It's, so on my sheet 2 of 3, kind of our minimum lot size here, 55 by 110, so 55 times 110 divided by 43560.
That's the width of the lots, 55 by 110 deep?
Yeah.
So 0.139 essentially, so 0.14.
Mm-hmm.
So the city just has a density requirement, but not a minimum acreage requirement for a lot, correct?
Not in a PUD.
Yeah, the PUD gives the developer the ability to, basically, you're making your project dense while providing a lot of open space. So what that does is it makes, you know, you protect the environment. There's a lot of trees you don't have to clear. Get the same number of lots, and less infrastructure, less paving, less snow removal.
This isn't gonna change though. This isn't gonna change whether you get 59 or you
Oh,
don't get
correct.
59, it's gonna stay the same.
Correct.
And if you don't get 59, what it's gonna do is gonna open up everybody's lot by a few feet, that's
Mhm.
about all it's gonna
Yeah.
do.
Not even all of them, just a
Just a
couple.
few of them,
Well, yeah,
and get the city less money in.
well, I know, but you know, here we go again, as far as green space and spaces where, that's, building that's going on, okay? That's why we have codes, you know?
But it's not gonna change the green space at all.
No, not the green space. No, it'll give all of the neighbors, and then if you turn it around again, that will be the only quadrant that will have, not 6.
And if you would dictate that, we could give more green space. You could say, you could say, we'll give you the variance, but get rid of lot 8. And then we would have to get rid of lot 8. We'd be fine with that. And that would give you more green space.
You, without green space, you give up lot 8 and you keep 59 is, I mean.
Oh, I'm sorry, I meant on the other side of that argument. I'm saying if you were saying with the more green space, we would,
Well, I'm talking for the owners of the properties.
oh, I see.
Okay,
I'm
as far
sorry,
as
I
green space,
misunderstood.
you have plenty of green space, that's planning commission, okay?
Mhm.
You know, what I'm saying is you give up lot 8 for lot 59 is what you're telling me.
Yeah. But obviously, that's not why I'm here. That's not what we're trying to get.
I know.
But yeah, and the numbers are arbitrary, right? Like, if you take out one, doesn't matter which one, your density goes to conforming, right?
Correct.
Can I ask a stupid question? What's PUD stand for?
Planned unit development.
Okay.
Did we get what they said about this?
The what? Memo?
Yeah.
I have some stuff highlighted if you want to mind, it's up
I'm
to you.
interested to see what you got.
Do we have any other questions from the board? What was the planning commission's main reason for the 58, that's code, okay? Did the planning commission give you any reasons why they don't want to let it go to 59?
Oh, I think it was the rounding. So they weren't allowed to grant us the 59 because technically it didn't round up to 59. So that's why they sent us to you.
They wouldn't have the authority to grant it.
No.
Right.
Is your 29.1 whatever acres, does that include all the hatched green space area that's not
Yes.
a residential? Okay.
Yep. Yeah, the overall acreage.
Got it.
That's in Macedonia,
That's in
not,
Macedonia.
not in.
Yeah, that's 29.1973 is the acreage we're allowed to apply to the density, which includes the whole boundary of our property minus the right-of-way, what's in the right-of-way,
Okay.
minus what's in Hudson. So that's just Macedonia outside the right-of-way.
Hudson, we have to consider as Hudson. I mean,
I
I know you
understand.
want to make it green space, but, you know, it's not green space Macedonia, it's green space Hudson. If you want to go play out there, go ahead, I mean, but we have to consider Hudson.
I understand, I agree with that. We kind of, that's the way we approached the project from the beginning, which is why we didn't show it. And we thought that since we're so close, we're 1/10 of an acre away. When we hired the surveyor, we were kind of crossing our fingers and hoping that he'd come up with more acres, not less, but he came up with a little less. So when we were kind of coming up with our strategy, I mean, it is, I think it's a valid point though, that he still purchased that lot, he's paying taxes on it. It's open space and it's, whether it's in Macedonia or not, I still think it's still part of the project. That's the way it
I
is.
read somewhere in there about him annexing it in the Macedonia, that property.
I didn't hear about that.
There was something in the planning about,
Yeah.
about going to council
Because
for a,
he could, if he did, it would
conform.
conform.
When they really do the real survey plot, okay, is it close to what they're coming up with, or how far are usually are they off?
I don't think I could answer that until they actually have the survey.
I mean, we've been through a lot of these, I mean, are they close to what we see on the print here, okay?
I don't
They're
know.
all different.
No, I don't know.
Well, I mean, I could kind of answer that number is the number that the surveyor certified. So, that 29.1973 is the acreage.
Okay. Gentlemen, any other questions? Do you have anything else to add?
No, I think that's it. Thank you for your time.
Chairman's open for a motion.
I'll move that we accept the variance as requested.
Second.
Roll call, please.
Mr. Bellato?
No.
Mr. Ferraro?
Yes.
Mr. Shalfo?
Yes.
Mr. Iafreda?
No.
It's a tie, the motion on the vote. So you need 3 affirmative votes, so the motion has been denied. So you have 58 lots instead of 59
Okay.
for your variance, okay?
Okay, thank you.
Thank you very much. Appreciate your time coming out and all your explanation. This is, yeah. Have a good evening.
You too.
Okay. Now we're gonna go to case 707. And is there any adjacent property or correspondence from any adjacent property owners?
Yes.
Would you please read them for us? Thank you.
It is from a nearby resident. He said he will not be available for the meeting, but wanted to share his concerns. As the property is currently allowing for overnight truck parking, I have noticed that there is more truck traffic in the evenings than on the weekends, specifically Sunday nights. As the parking lot is not paved, it creates huge dust clouds which flow to property owners across the street. I also have concern that if parking is allowed to continue, that some of the units could have refrigerator units on them, which would run overnight and create additional noise. I don't believe that any additional trucks should be allowed to park there if they are not associated with one of the current tenants in the building. The way the building was constructed and laid out, the lot is visible from the road and was intended to be used as a terminal or to have a lot of truck traffic.
Is there any unsolicited correspondence regarding this case?
No.
Will the zoning inspector, well, before that, I would like our law director to explain to the board, okay, what we're actually voting on. It's not a variance,
Thank you.
it's an appeal, so this is a little bit different than we're accustomed to, but would you please explain, Mark?
Sure, yeah, so obviously in the BZA's history, it has received appeals, quote-unquote appeals periodically. That is different from an area variance request where you're used to considering the Duncan factors or a use variance request. This here is an appeal of the administration's determination, here Mr. Hall's determination, and you have his memorandum summarizing the issue. The board's job right now is to review this almost like a court. So this is where you get your quasi-judicial capacity from, because this is an appeal and you're looking at the city zoning inspector's determination and looking at the code to determine whether you believe that determination was appropriate or not under the law. So you're essentially acting like a board of judges to decide whether this ruling was appropriate or not. So they've submitted it. What the city's code requires is that you have the hearing within 30 days of the appeal, which you're doing. You have 30 days from today's date to make a decision. That can get bumped to 90 days if you request additional information or agree with the applicant on a different timeline. But otherwise, you have an obligation to make a decision within 30 days of today's date.
So what is our obligation for this evening?
So you could take evidence, obviously there's nobody here to provide evidence from the applicants, but really you'll look at, Mr. Hall will read the city's position, you'll take that into consideration in light of the codified ordinances essentially, and determine whether that's appropriate or not. You can make a motion tonight to decide the issue, or you could bump it for another meeting if you decide you need some more time to consider it.
Thank you.
Any other questions, Law Director? We okay? All right. Will the zoning inspector now please state the city's position?
The Board of Zoning and Building Code Appeals will hear a request for an appeal for the address at 9260 Valley View Road. The appeal is in regard to the zoning inspector's interpretation of 1169.03 B, C, and D, that truck parking is not a permitted use in an LI limited industrial district.
Does any of the board members have any questions to the city?
Have they been parking trucks there?
Well, I think he said in his letter to the city since 2009. So,
And by parking there, it has been against the code.
correct.
Has he been cited, fined in any shape, form, or fashion?
No.
Answers that question, don't it?
Well, there's two, Mad Jim is a truck repair place, and the city, I believe they signed the occupancy permit for him as approved. And this was before I came to work at the city of Macedonia. And then Naylor Landscaping, they received the variance to have outdoor storage, and they allowed the landscaping company to be on the property. And I mean, he occasionally will have a truck in there, not a semi. But Mad Jim has had trucks there since day one, and I mean, you don't know whose truck is whose when they park there.
I guess my question is that truck parking is not a permitted use in an L1 limited industrial district. Is the building in an L1 limited industrial district? So is our code correct and they're incorrect? So by you going out there and telling them that you can't park trucks here, is that correct or is it incorrect?
I believe Mr. Dollywell purchased that building from the summer, Homer Summer, just within the last, I'd say 6 months, 8 months. And they've been parking trucks there for as long as I've been at the city. According to the code, truck parking is not a permitted use. When you look at 1169.03 B, C, and D, it's not permitted. It's actually not a permitted use, and therefore, it's prohibited.
Is Crown Space LLC just the building company, like the company that owns the real estate, or do they actually do anything, like,
That's
in
the
the building?
property owner that purchased 9260 from Homer Summer, who passed
Yeah,
away.
that's their LLC name.
Yes.
Okay, but it's not, it's a real estate business, it is not it's not occupying the building.
Not a retail business, no. No.
Or even a commercial.
They have 2 or 3 retail businesses in there, correct?
I know for sure Mad Jim,
The stone
Maybe
company's
landscape.
in there and then landscape.
Are you asking if the applicant has a current permitted use on the property? Is that what you're asking? Is this applicant, do they have a permitted use to operate on the property?
he has applied for occupancy, which has been denied because it includes truck parking. So I believe he has an office in there, but I don't know for sure.
But
He's
an
not on
office
the
is not
property every day.
permitted use, right? Per the code.
You have your permitted uses, like Mr. Hall said, in
Right.
subsection D1 there.
Right here.
And then,
But basically, we're voting on, is truck parking, okay, allowed in an L1 industrial?
Mr.
And
Dollywall would like 10 trucks to be parked on the facility. He is a truck owner himself. And I believe it explains in the document here that he has 1 or 2 trucks. There's 3 additional people that want to rent space from him, I believe that's the number. and then
Truck
5
space.
additional,
Truck
so 10 total spaces to be leased out.
Is there
On the
anything they
premises.
could do to be in, is there anything they could do to be in compliance? I mean, if they put a fence up, or they put privacy, or
A variance
paved
request?
it, well, besides variance. I
Or a
mean,
building.
Or if it was, some, what is it, concrete or asphalt or something, or is it,
I think the only,
Go ahead.
I think the only way that it would be permitted is if he does a use variance, and the Board of Zoning allows him to have truck parking on the property. As a permitted use, it's not permitted.
okay.
I have a, oh,
Go ahead, were you gonna say something, Mark?
Yeah, I was gonna say, so typically, for the board to grant a use variance, most municipalities view it that it has to be a permitted use somewhere.
Right.
And I think what Mr. Hall is saying is truck parking is not a permitted use or a conditionally permitted use within the city. It's an accessory use if there's a permitted use or a separate permitted use or a separate conditionally permitted use. Then truck parking is provided in the city's code as an accessory use, if that makes sense.
so would Mad Gym be considered an accessory use because they do truck repair? Or,
The applicant is Crown, whatever.
It's not Mad Truck.
okay, so is Mad Gym renting from Crown? Or is it just adjacent
Yes,
property?
he's renting
He's
from.
renting. He's just renting the building. So if he has an obligation not to keep any trucks outside because of the repair, then that's what he has to do.
Sure, so this says, the building permit issued in order, remove all semi-trucks and trailers that are not being serviced by Mad Gym or they're not owned by the property owner. Can you explain, there's 2 exceptions in that statement. Can you explain those 2 exceptions?
Well, I mean, when you look under 1169.03, all activities, operations, and storage shall be completely carried out in wholly enclosed buildings except for accessory off-street parking and loading, and trucks or other motor vehicles used in the operation of the business. So, if there's a business there,
So Mad Gym meets that criteria theoretically, right? As just Mad Gym, not all the other trucks.
I
Well,
don't
I
think
don't know.
Mad meets that, he just
No.
happened to appear there.
If he repairs inside the building, he meets that criteria. But if he pulls a truck out for overnight or for 3 weeks to get a part,
Oh,
then
okay.
he's not meeting that
When
criteria.
it says not being serviced by Mad Gym means not within the building being
Right.
serviced. Okay,
Right.
not, okay. I
Yeah,
misread
because
that.
there's no truck parking allowed.
Or not owned by the property owner, what allows the property owner to have a semi-truck?
Well, if they do distribution, they have a warehouse in there, and they have a truck on the property to ship product somewhere and then come back and reload, that would allow them to have a truck on the property.
Yeah, again, kind of what I said earlier, those get to the usage being an accessory use
Okay,
instead of permitted
Which is
use.
here.
okay, okay.
So
Yeah, I've seen.
I know,
yeah,
I was looking at it,
Trying
so.
to understand.
do we know what all this package, there's all kinds of pictures here, so, I mean,
I don't know anything about it.
agree.
I'm just saying, so I know that they don't have to be here, this is an appeal,
Right.
but can we request them to come?
Well, their
You can-
attorney was supposed to be here this evening, okay, and go over everything about this project.
I understand that, but we don't know exactly what happened, why they're not here.
You know about attorneys, you never know when they're
Well-
gonna show.
Whatever.
We don't know what
You
other people are going through. So I'm just saying, this is not something that's do or die immediately. I just think,
Well, we're voting on the code, that's what, I guess what I'm looking at, okay? It's not a variance, where that if they have to sit here and say, hey, and give us a whole spiel
but
on what's going
we're
on.
deciding on an appeal, which is different than a variance.
Which is,
That's correct.
I think the materials speak for themselves.
Deny
That's
the
right.
appeal, they can actually apply for a use variance if you deny, is that?
They,
But we
they may
wouldn't-
try to do that. I don't know what their plan would be
Right.
if you denied
You're
this.
saying
I wouldn't
regardless-
wanna speculate.
Regardless, we wouldn't be allowed to grant use variance because it's not a permitted use within the city.
Well, we're not even.
We're not even
That's not
talking about
before
it.
us.
Right, I'm
Right.
saying, but
It's
it's
just an
even if that was
And I
the
think
case,
your word is saying that everything in front of us
speaks for itself.
speaks for itself.
We had the,
Okay, so me personally, I don't need anybody to show me what the L1 is supposed to have, and it's a city ordinance. That's what I'm looking at, so.
I agree.
I'd be interested to hear their side of the story though.
To me, it's almost like we heard their side of the story
Mhm.
through a lawyer.
Well, yes.
And-
That's what's printed.
And
Anybody else have any questions to our law director, our city inspector, any of us? I'll make a motion to deny case 707.
well, are we supposed to do it in the affirmative?
You can do it either way, but, so why I made that recommendation in case 705, because if you have the motion phrase in a negative and then it doesn't pass, that doesn't mean it passes, but it's not really clear what that means. And I've had this issue on an appeal before. It's cleaner, and you can make the motion in the negative. If it passes, then it's obvious that it fails. But if the motion in the negative fails, you're kind of left in a gray
You have to
area.
revote.
So in that instance, and if your preference is to vote in the negative, that's fine. If it passes. If the gray area is when it doesn't.
Yeah,
So then, in those instances, do the motion in the negative would be my recommendation,
okay.
or in the
So are
affirmative.
we okay to do it the way we're doing it?
You can do it how you're doing it, yeah. You can do it how you're doing it.
So I will repeat one more time.
Sorry.
I deny case 707.
Yeah.
I make a motion.
I second.
Roll call, please.
Mr. Colado,
Yes.
Mr. Ferraro,
Yes.
Mr. Shalfo,
No.
Mr. Iafreda.
Yes.
Case 707 has been denied. Thank you very much.
All right.
Yeah.
Man, I'm impressed. That was good.
We're doing it.
Yeah.
Motion to adjourn?
I make a motion, we adjourn this meeting on the 18th of September, 2024.
Second.
All right.
Meeting is done. Thank you very much.